Make no mistake about it. This case is about the Minneapolis Police Department and Derek Chauvin and the shameless standby police officers who were on scene, who had every opportunity to stop and prevent a senseless death, a needless one. They were compliant with with Officer Chauvin, who had his knee on George's neck. This was a brutal and public display of an 8-minute prolonged death. This was the lowest level of human respect and dignity that any community should ever have to endure. What this really was the weight of the Minneapolis Police Department on George's neck. And what you're going to hear from the doctors is that there were 2 actual physical mechanisms that were in place that caused George Floyd's death. As Ben alluded to, not only was the knee on George's neck a cause of his death, but so was the weight of the other 2 police officers on his back, who not only prevented blood flow into his brain, but also airflow into his lungs. That makes all of those officers on scene criminally liable and, without a doubt, civilly responsible. Had the Minnesota Police Department instituted the reforms it promised it would when it came to chokeholds and restraints, George would be alive. That's because the Minnesota Police Department, through its custom practices and policies, failed to train its police officers, failed to discipline police officers like Officer Chauvin, kept them there, kept them on scene, kept them on the police department. The Minneapolis Police Department promised that it would train its police officers on chokeholds and restraints. It promised that back as long as 2013, and it failed to do it. What you see on the video is exactly what happened.
Welcome to Law and Crime Report. I'm Ashley Willcott. Happy to be with you. It's always an honor to be with you, listeners, and watching this. That was regarding George Floyd. Most of you have probably seen the horrific video that's made its rounds around the nation, around the country, around many countries because of the brutal murder of George Floyd. Now, there are 4 officers, as you know, that have been charged with his murder. Now, the defendants are trying to say, listen, these should not be tried together. And the reason they shouldn't be tried together is because there is different evidence and different defenses, and there's going to be finger pointing. So it's going to be interesting to see what happens. The state says, no, these 4 defendants should be tried together. The reason is it's the same evidence, the same witnesses. They acted in concert. So I want to bring in my special guest today, Gene Rossie. Always happy to have you, former federal prosecutor. We have a lot to talk about in what's going on in this case. So Chauvin, as we know, represented by Eric Nelson, is one of the 4 defendants. He's the one in the video that actually has his knee on George Floyd's neck. And what they're saying is, hey, he needs to be tried separately. There's no reason he should be tried with any other of the other 3 officers accused. What is your thought first about that one officer being tried separately or with the other 3 officers facing charges?
I think that Mr. Chauvin, or Officer Chauvin's attorney, is making a very good argument. And I think the other 3 officers are making good arguments. I don't think they're going to prevail at the end of the day, but the argument they're making is this. You want to avoid a circular firing squad where everybody's pointing at the other defendants. And what that does is it mitigates the defenses each officer may have, and it's prejudicial to them because they will say, I didn't do it, the other 3 did it, or at least 2 or 3 did it. And that prejudices their argument of I didn't do anything to contribute. The counter to that by the prosecutor is this, and you hit it on the nail, Judge Ashley. Same evidence, same witnesses. The famous phrase, though, is judicial economy. It is a complete waste of the court's resources and the public fisc to have 4 separate trials. So I predict these motions will be denied.
So, Gene, though, let me play devil's advocate with you, because we know from the video that 2 of the other officers were holding the legs of George Floyd. The 3rd officer was actually doing crowd control. So just for those watching, Alexander King, Tu Tao, and Thomas Lane are the other 3 officers. So devil's advocate, they're in different positions to see what's going on, to know what's going on. And so isn't there a good argument by their attorneys that, look, my client was one of the ones holding a leg. He couldn't actually see what Officer Chauvin was doing to George Floyd. And the one on crowd control could say, hey, they were all 3 behind me with George Floyd. I have no idea what happened. I shouldn't be criminally liable for this.
Well, Judge Ashley, you're making a great point. And I think the defense attorneys will do the best they can. I'm just saying at the end of the day, there's a predilection, a proclivity for courts and judges to put all defendants in a case involving the same witnesses, the same evidence. It's not a long event. This is not a complicated case. And I can see a judge saying, you know what? I agree with you, defense attorneys. I just think at the end of the day, your arguments don't hold water, and we're going to keep them all together, and we will not sever the case.
All right. So we know one of the arguments by attorney Eric Nelson has been, look, there's going to be finger pointing. And in fact, it's going to be antagonistic. They're going to blame each other. And in doing so, that's going to hurt my client, the primary defendant who had his neck on his neck. It's going to hurt his defense in this case. Now, we have 4 defendants, all on scene, all charged with various crimes, but all being held or potentially being held criminally responsible. I don't think it's that unusual, Gene, to see the defense say, hey, listen, because they're going to blame each other, we don't want these together. But on the other hand, of course they're going to blame each other. Isn't that what co-defendants do when they're tried together? Don't they often point the finger at one of the other defendants?
Absolutely. The best statute for any prosecutor at any level is conspiracy. Now, they didn't charge conspiracy, but it's essentially a conspiracy, aiding and abetting. They're all in it together, and they allegedly took the life of George Floyd. If I'm a prosecutor, I want all 4 defendants there, period. Because if any of them takes a stand, this is what's going to happen. The prosecutor obviously will cross-examine, but the other 3 defense attorneys are going to be cross-examining. And I can tell you this, prosecutors love when another defense attorney is cross-examining another defendant. It's a beautiful thing.
Sure, but here's what else bothers me about this case, and that is the blue line. They were all officers, and so you typically hear they stand up for one another, the family, the fraternal, all of those things that exist among law enforcement. And I think very, very highly of law enforcement. Now they're former officers. They've all lost their positions. Does that make a difference in terms of how quickly they may or may not throw each other under the bus, so to speak, when it comes to their legal defenses?
Well, when I represented defendant and when I was a prosecutor, I always said to each defendant or cooperator, the most important person in your life, as I speak to you now, is yourself. And you got to think about you. Don't worry about the other 3 officers, because you can guarantee they will throw you under the bus in a New York minute if it would help their case. So what I hear and see in this case and read is that these officers, there's no joint defense agreement. There's no kumbaya. We're all going to get together, thin blue line, all for one, one for all. They are all independent contractors, 4 people trying to fight for their lives and their liberties. That's what I see.
Yeah, absolutely. Now, the other thing that's going to be interesting, we expect there to be a hearing on Friday by Judge Cahill, and there are 3 things I understand he's expected to consider. One is the joint trial request by the state saying we want to try all 4 of these defendants together, and then 2 defense motions. One is a change of venue, and the other is sequestering the jury. Let's talk first about that very first piece. And I know we've talked about it, but the joint trial request by the state. Do you know, Gene, is it typical that that co-defendants are tried together, or rather does the state or the federal government have to come in and prove that it's the best thing for them to be tried together?
If I'm defending against this motion as a prosecutor, I'm going to say the following. Your Honor, judicial economy, I would ride that horse till the cows come home, because it is a pain in the neck to have separate trials involving a relatively simple case. No disrespect to George Floyd's family. This is a simple case involving 9 minutes, and it's one scene of the crime. You don't need a lot of, evidence or documents here. And I would say to the court, it's COVID time. We're going to get 4 juries during COVID season? No way. And I got to tell you, the only motions that I see that should prevail is change of venue. I don't think these officers are going to get a fair trial in the Minneapolis area. They should go to the farthest county in Minnesota to try this case.
So, Gene, you took 2 things right out of my mouth. One is COVID, because that does make a difference. Like you said, no, that's good. We think alike. I love having you on, because it is true.
Great
with
mind.
COVID, it's a whole different, that's right. It's a whole different beast to try a case. We know that during COVID, to have a jury, and a lot of courts aren't even back in session yet. So, number one, 4 juries that don't have any individuals who have any predisposition or biases that can hear this case, that's a tall order in any times, much less during a pandemic. The second thing you mentioned I want to delve into is, you said the change of venue would be appropriate in your opinion, the publicity aspect of this. So as a judge, if I hear George Floyd case is coming, we know everybody in the world knows about this case because of the horrific facts and circumstances that surround it and the murder of this man. Having said that, I want to know this. Does publicity, in your opinion, affect, first of all, whether or not there should be 1 trial versus 4 trials?
I think it's better publicity-wise if you have 1 trial. If you have 4 trials, you're going to have 4 presentations of the testimony. The word gets out regarding each defendant, and pity the 4th defendant. If you had separate trials, pity the 4th defendant who has to go to trial if you did have 4 separate trials. And Judge Ashley, the famous case is Ohio versus Dr. Alan Shepard, 1965, or Supreme Court reversed a conviction because of this Cleveland case. The Supreme Court of the United States said the publicity surrounding that deprived the defendant, Dr. Shepard, of his due process rights. That's why I think the prosecutors should agree to a change of venue to Duluth, to the farthest county in Minnesota.
Yeah, you know what? I don't disagree with you. You heard it here first. We're also going to find out whether or not the jury is going to be sequestered. I think, in my opinion, there's no choice. They probably will be, again, given publicity. We're going to take a really quick break. We'll be right back on the other side.
I just want, it's not that all lives don't matter, but right now, our lives matter. Black lives matter.
Yes.
Black trans lives matter.
Yes.
Trans lives matter.
Yes.
Because guess what? We all minorities, but right now, like, let's focus on the person who got killed. Tony McDade was a black trans man. Okay?
Amen.
We're not doing this. We doing this for him. We doing this for our brothers and our sisters who got shot, but we doing this for every black person. Because at the end of the day, I cannot take my fucking skin color off. I cannot mask this shit, okay? Everywhere I fucking go, I'm profiled whether I like it or not.
That ain't right.
Like, I'm looked at whether I like it or not.
That ain't right.
First of all, I want white people to realize their fucking privilege.
Yes, ma'am.
No one can look at you and tell anything about you unless you give them that information. Wherever the fuck I go, I'm profiled. Look at my fucking hair, look at my skin, bruh.
We love it.
This shit, I can't take this shit off, so guess what? I'ma die about it.
Yes.
I'ma die about my fucking skin. You cannot take my fucking blackness away from me. My blackness is not for your fucking consumption.
And welcome back to Law and Crime Report. This is just a horrible case to talk about, but we always bring you the breaking news from across the country, and this is out of Florida. That was activist Toyin Salo, a 19-year-old that you just saw speaking at a march for Tony McCabe. And after that, she tweeted that she had been the victim of an assault, and then she went missing. Now, this was on June 6th. Her body was later found on June 13th. The man accused of killing her is Aaron Glee Jr. Now, Aaron Glee Jr. actually confessed to killing her, that he had gotten them a ride to his home so she could get cleaned up to rest because she'd been assaulted, and it went downhill from there. He confessed to, and this has all been released in probable cause documents, court documents that we've obtained, all of this information. He confessed that after they went home, he basically, they asked, raped her, and he nodded in the affirmative, or answered in the affirmative that yes, he did. That she then, he wrapped her up and taped her up, wrapped her up in a way that she could not breathe. She was found in his home deceased on June 13th. Gene Rossie, former federal prosecutor, is still with me here to break down all the latest cases. This one is especially disturbing. All of them are, but this one is especially disturbing when you have a vibrant, beautiful, young 19-year-old activist, outspoken, peacefully protesting in that video, and yet she's the victim of this type of crime. Tell me what you know about any of the circumstances or likelihood that it just appalls me that here she is being so outspoken, and then you hear about she disappears and her body's found on June 13th. Gene, what are your thoughts?
Well, she's talking about the sanctity of human life and being a Black person. And what is sad about this is it has nothing to do with police violence. Her life allegedly was taken by another Black person, and that is equally sad. And what is sad about this is the premeditation that this man allegedly engaged in, Mr. Glee, Aaron Glee Jr., and that he let her stay at her house after she had been allegedly raped, and he probably tortured her, tied her up, then he took her life. And I got to add this, though, and we talked about this off camera, Vicky Sims, who's 75, he also took her life. Now, Mr. Glee did not allegedly confess to her death, but circumstantial evidence shows, because her body was found at his home, that she also was killed by him. And probably what happened is she went to his house, Miss Sims, probably discovered the body of Miss Salou, I think it is. And that's why her life was taken, because Mr. Glee allegedly didn't want to witness.
That's exactly what I think happened. And yes, it's circumstantial, but this 75-year-old lady is known for taking food to him, for giving him rides. He didn't have a car. In fact, she was the very person that he called to get a ride for himself and the young activist to go to his home. So here you have another person who is helping, trying to do the right thing. And she, again, like you pointed out, her body's found in his home. Now, the other thing when he confessed, Gene, I know, it never ceases to amaze me what I hear alleged murderers or criminals say in court, but he did confess. And do you know that part of his confession was to avoid prison seemed that the only course of action was to end her life? Are you kidding me? That's why he says he killed her. And then he ends up getting caught. I just have to point out, he bought a bus ticket to West Palm Beach, and that was 2 hours before the bodies were found at his home. He was actually then detained on June 14th at a Greyhound bus station. So he has all these, I agree with you, predetermined steps that he's making along the way. He says, well, I had to end her life, so I didn't end up in prison, all for naught, because he was arrested and he's confessed. Now, of course, he has a trial coming, but he has confessed at this point in time. Gene, what are your thoughts about some of these criminals and the things that they say and do?
Well, you got to understand, most criminals are stupid. That's number one. And the ones who think they're smart are actually stupid too. But criminals do not think logically. They don't think rationally. They think criminally. And he raped her, realized that she was going to report her, and he just said, you know what? I have to take her life because I don't want her being a witness. And I think that's probably what also happened to Sims. Now, going to his confessions, And as I understand it, he confessed to, I think it was in Orlando. He also confessed to Tallahassee police and I think a third party to his mom. I think they recorded a call or may have recorded a call to his mother. So after he killed, allegedly, these two women, he probably had an epiphany and realized this. I'm going to have to plead guilty. I will be surprised if this goes to trial. I got to plead guilty because that's the only way I'm going to avoid the death penalty.
Yep. So we're going to wait and see on that one. Law&Crime, of course, will continue to bring you updates as we know them on that case. Gene, I want to switch gears now because we're going to go to Colorado. We cover cases nationwide. And this one is equally appalling, but for different reasons. This is a 12-year-old taking a virtual art class. You heard me right, a virtual art class. And during that virtual art class, he has a gun. Now, I've seen a picture of the gun, and it looks to obviously be a toy to me. It's green, it's black. It says, I think, zombie or zombie hunter on the side of it, and he has that. So as a result, imagine this, if you will. You're the mother, you're at work, you get a phone call from the vice principal of the school that says, hey, by the way, we've called the police. They're headed to your home where your son is doing virtual art class. What? Why? Well, he appeared to have a gun. So off the police go to the home. Gene, I'm going to stop there. I'm going to tell the rest of the story in a moment because there's more to come. But knowing that, what do you think about the schools deciding to call the police in response to what they saw on a virtual class?
Well, I think they definitely should call the police because this is a criminal act. He's 12, but it is a criminal act. You're threatening somebody. Whether it's in person or online, it's still a threat with what appeared to be a firearm that a reasonable person would think would be a firearm, even though it ended up being a toy gun. And I think they did the right thing calling the police. Now, we could debate on what the punishment should be, but they definitely should have called the police.
I think that a defense attorney could have some good arguments in this case. And I'm looking at some of the direct language. The school released a statement that said it was a facsimile of a firearm brought to school. I think there's some arguments to suggest, is virtual education really school, quote unquote, and meaning that bringing a firearm to school virtually is an issue? That's number one, I think, is a potential argument by the defense. And the other one is whether or not the toy is a facsimile of a firearm, most likely. But the last piece of this is, what did he do with that gun? And we don't know that yet. So I understand, Gene, if he's a threat to himself, to someone else, then yes, police need to be called. But does it matter what he did with the gun during that virtual class? We don't know if he waved it around, if he pointed it at the screen, if he pointed it at himself, if he said, I'm going to kill you. We don't know what exactly at this point he did or said while he had that gun. Does that make a difference to you?
Oh, of course, because that gets to the reaction of the person. If I tell you right now, hey, I have a pen, but make believe it's a gun, and I'm going to shoot you, Judge Ashley, you're going to laugh at me, okay? Because it's a pen. It looks like a pen. I've just told you it's a pen. If he did things like that, like I have a gun, it's a toy, you know, teacher so-and-so, hey, I'm pointing at you, ha, ha, ha. That's not really a crime. But if he gave the indication over electronic means, and that's a crime too. That's a federal crime, actually. Making a threat using the wire or any lines of communications. I represented somebody who did that. That's a federal crime. So it depends on exactly what he did and what that gun looks like, toy or otherwise, and his words that accompanied his brandishing, whatever it was. It's a factual question.
It is a factual question. Now, I understand that the mother did review the video, and it appears, according to her, as if he did not brandish the gun that we now know was a toy gun. But, you know, this raises some fascinating legal questions in my mind, Gene, and here's why. I think now, given many schools are operating virtually, and I'm grateful for that. Thank goodness children can get an education, even though they may not be able to go in person because of a pandemic and the safeguards in place. So it's great news to me that they can attend school virtually. But I think you raise a really good point. Is this going to open up a whole avenue of potential federal crimes because it's over the internet if they commit a crime or allegedly commit a crime while they're attending virtual school? Are we going to see more instances like that? And Gene, is school policy going to need to adjust? Because the mother's point in this is he is an African-American 12-year-old. The police are a threat to him from the mother's perspective. I'm afraid of what's going to happen, what they're going to do to my son. So from her perspective, the school created a higher risk for her son, and they shouldn't have done that. So to me, there are issues around school policy and laws. And does the school in a virtual situation like that have an obligation to talk to the parent first, or rather call the police? What are your thoughts around, I think, this whole new area of law and potential criminal charges?
Well, I have to see the tape, because if it was an innocuous tape and it's clearly a joke, the school officials maybe should have called the mother first. But if it was egregious conduct, I don't have a problem. No disrespect to the mother who's trying to protect her son, but I don't have a problem if it's egregious. But regarding threats over the virtual ways, a phone or by Zoom, you're looking at interstate commerce and you're touching on federal crimes. And I don't care if you're 12-year-old or 82 years old or 12, if you make what appears to be a threat that a reasonable person would take as a threat, it's against the law federally. I represented somebody who made a verbal threat. He thought it was a joke, but he got charged and he pleaded guilty. So it just depends on the facts. It really does.
And that's why I love Law and Crime, Gene. Thank you for your insight, because it helps everybody know and understand it is a federal crime. And so you have to be aware of that. Now, the child's father, 12-year-old's father, Isaiah's father, was in the house, as I understand it as well. So stay tuned. We'll bring you any additional news on that case when we get it. Now we're going to take another short break, but we'll be right back with more coverage here on Law and Crime Report. Welcome back to Law and Crime Report. Judge Ashley Willcott here with you. We're continuing to cover the nation's greatest, newest stories. Now we're going to go straight to Delaware, where two women are accused of stealing a Make America Great Again hat off of a person. Now, it was outside the Democratic National Convention, and as luck would have it, it was taped and posted on social media. Let's take a look. And gone are the days of peaceful protesting, apparently, by nature of that video. We can see now these two individuals are facing criminal charges, but they also are only 21. So, Gene, I'm going to bring you back in. Gene Rossie, our former federal prosecutor. And let me just say this, they're kids themselves, but the behavior is pretty unacceptable. The victim in this case is a 7-year-old. They took the hat off a 7-year-old, and then you can see what ensued after that. What's your gut response?
You know, I ran for Lieutenant Governor of Virginia in 2017. I gave hundreds of speeches, attended many rallies with people, obviously, that agreed with me and didn't agree with me from both parties. And I got to tell you this, I was lucky. Everything was peaceful. I never experienced any threat of violence. I got a few arguments, but I never had any violence or even threat of violence. My blood pressure boils beyond compare when I see these two immature, adolescent, stupid 21-year-olds. And if I were the prosecutor, I would charge and make them eat a misdemeanor, but I would seriously think of jail time. They crossed the line by just beyond losing your temper. You know, you didn't like the MAGA hat, you didn't like the Trump poster. You crossed the line and you caused serious emotional harm to a young child, 7 years old, and also to the mother. So I wouldn't say they get 50 years, but I would ask for some jail time. That's how egregious this is to me.
Yeah, and you wonder, these 21-year-olds, what type of life have they had or experienced where they think that this behavior is acceptable? I'm not condoning it, I'm not excusing it, but I would just suggest 21 is rather young. Having said that, as a mother, I was incensed because if anyone laid a hand on my 7-year-old, I would go crazy, and it would not be the end of that. I would too. It wouldn't be the end of that altercation. And you can see the problem is too, when the mother tries to step up and when the little boy says, "Give me my hat back," if they just done that, it would have ended everything. But they refused to do that. They didn't back down. They kept attacking. Then they take a swing, one of them does. So it just continued to escalate. Now, I want to talk, Gene, you did say criminal charges. Let me just talk about, and I have to have them written down thanks to our amazing producers because there's so many of them. These two 21-year-old defendants are charged with second-degree robbery, second-degree conspiracy, endangering the welfare of a child, third-degree assault, attempted third-degree assault, offensive touching, and felony hate crimes. Now, knowing we just saw in that video what happened, Gene, is that overkill? Is that too many charges in your opinion, or do you think it's appropriate to throw the book at him and charge him with everything possible?
No, and here's what I would tell, and I gotta compliment that mother. That mother showed some grace and charm because Judge Ashley, I have 3 children. They're all, well, they're all mature on paper. But if anybody ever touched one of my kids when they were 7 years old, I got to tell you, I don't know what I would do. So that mother showed a lot of grace and charm in just videoing. But I would charge a misdemeanor, but I would ask for some significant jail time because I want to make sure that mother is we think about what harm to the child and to the mother. If they have no criminal record, I don't think a felony is appropriate. I'm being a softie on this, but I do think they should go to jail for some period of time and eat a misdemeanor, a series of misdemeanors.
So, you never know what you're going to do until you're in a circumstance. But as I watch that, the one thing I feel like is walk away, walk away, walk away, because in the world today, we don't know if people are being antagonistic. Do they have a gun? Are they going to do something really awful? And so a part of me as a mother thinks, get your child and leave and call the police, leave, call the police, look at the license plate, report it, leave, call the police, because you don't want there to be further threat or risk to yourself and your child. Now, I've read some reports that say, you should have taken your child out of that circumstance, Mom. You should not have said, go get your hat, go get your hat, go get your hat, and put your 7-year-old in a situation where there was some individuals who are clearly angry and not behaving well. What are your thoughts around that?
Well, that would be part of the calculation and considerations in charging a misdemeanor because, the mother she showed reservation and composure, but she didn't follow them and kind of poke the bears, if you will, and kind of get them to act even more immature than they did. Ideally, she just should have called the police, said they took my hat, and they made remarks to my child. They ripped up my poster. That would have been the end of it, and the police would have acted. But they kind of poked the bear a little bit, and that would have been something that I would consider. But I got to say this: if they have no criminal record, I am fine with misdemeanors with jail time. But if they do have a criminal record, if they do, I would charge a felony.
All right. So it's going to be interesting to see what happens. And again, I don't want anyone to think that I'm stating the mother's behavior caused any of this or is an excuse for what happened. We're just talking about the pros and cons of what you do if you find yourself in an untenable position like this. Now, the next thing I want to talk about, the charges they face, Gene, it's my understanding, could mean that they would spend up to 15 years in prison. So what do you mean when you say I want to see them spend some time in jail? What does some time look like? Let's say first for 21-year-olds who don't have criminal history, if in fact they don't.
I would make them an offer of the following: 3 to 6 months and plead to a couple appropriate misdemeanors. I do think 3 to 6 months, and they're not going to go to Sing Sing or Alcatraz Island. It would be a minimum security prison. They're 21. They are mature. They can vote. They can join the military, obviously. But 3 to 6 months. And I know the mother, God bless her, she probably wants, a lot of jail time. But I think justice is served, and the punishment is going to send those kids, and they are kids in my book, a message, and it will show respect for the political process. But definitely they should go to jail. Definitely go to jail.
And my juvenile court hat, I can't help but put it on and say, I also hope that they get some type of, social manners classes, courtesy classes, anger management, something to help them understand at this young age it's not the way to behave, and in fact, it's criminal behavior. Having said that, you are not going to want to miss Kevin Spacey's in the news, and we'll want to hear why. We're going to take a short break and come back on the other side with more on Kevin Spacey. Welcome back. So Kevin Spacey is in the news. I told you it was coming. Here we go. Again, he's being sued by actor Anthony Rapp and another man. Now, both of these individuals are claiming that Kevin Spacey, the actor, and we know that he had somewhat of a fall from grace after some other allegations were made some time ago, and they are saying that he actually assaulted them when they were 14. Now, one of the actors, as I understand it, there was a sexual interaction between Kevin Spacey and himself. The other one was not a sexual assault. And I would suggest maybe it's not just an assault, but rather grooming, because when you have an individual, if in fact the allegations are true, and I say if because he's not been charged, he's not been convicted, he's being sued by these two men. If in fact it's true, then a 14-year-old, I would suggest, is actually groomed before they're assaulted. Gene, Rossie, bringing you back in. Tell me your thoughts.
Well, you hit the nail on the head. When you have young victims, like the two alleged victims here, Mr. Rapp and victim CD, there always is grooming. You kind of bring those young kids into your world and you befriend them. And, the allegations about priests are great examples. And you bring them into your world. You earn their trust. They become friends with you. They look up to you, and then you pounce. And this is allegedly what Kevin Spacey has done to Mr. Rapp and victim CD.
And do you remember there was an 18-year-old in the Hamptons, and he was part of the staff at a restaurant or a bar in the Hamptons, and he alleged that he was in fact assaulted by Kevin Spacey. Now that case went away because, as I understand it, he did not want to prosecute, was not going to testify. So now you have allegations by an 18-year-old. They were just that, allegations that went away, and now you have allegations by two individuals, both of whom say it happened when they were 14 years old. is it where there's smoke, there's fire, or is it Kevin Spacey's a big Hollywood name? I think he's an excellent actor. Are they simply going after him because it's been brought up before? Which do you think it is?
I think it's more that he may have actually done these crimes. Here's the thing. I think Kevin Spacey is a brilliant actor. I am a big fan of his as an actor. And The House of Cards is brilliant. And we just talked about that. But these allegations are very, very disturbing because you're right. In the law, they call it 404B, Rule of Evidence 404B. It's not just he did it once or twice. We're now in the double digits here in terms of allegations. And I got to tell you, if he goes to trial on one or both of these alleged victims, it could be very difficult for Mr. Spacey.
And I want everybody to be aware that RAP actually brought these accusations against Kevin Spacey in 2017. So this is not new. We're in 2020 now. 3 years ago, he first brought these allegations up. And I just have to put myself into the world of Hollywood for a moment. And what I mean by that, Gene, is I think when you have any famous actor and you see them on the screen and they're so good at their craft, of course, I think you'd be thrilled if you have a child who's 14 and they want to be an actor, or if they get a bit part in a movie or a big part in a movie and they're involved with some of these Hollywood types. I think that there's a natural inclination to think, well, it's Kevin Spacey, or it's, whoever else it is that's a big time A-lister star. And of course it'll be okay. Why would you think otherwise? So, my fear is, if in fact these allegations are true, that he probably had a lot of exposure to 14-year-olds, to other aged children that he could potentially have assaulted.
Oh, when you have allegations like this and you're hitting double digits and you charge somebody, what inevitably happens is you get more people come out of the woodwork and said, you know what, I wasn't going to come forward, but now I feel emboldened because these other individuals are coming forward. I think I owe it to him. I can think of politicians up the wazoo. Jeffrey Epstein's another example, Harvey Weinstein. So when charges are brought, it usually brings out individuals who allegedly may have suffered the same crimes, and they feel that they have to support the individuals who have come forward. So if there's more allegations out there, they probably will come forward once charges, if they are brought, against Mr. Spacey.
Yeah, it's like the beginning of the Me Too movement. It does empower individuals who have also been victims to speak out. Now, let's talk about statute of limitations. So assault, I don't know what that exact statute of limitation is, but potentially, is it correct that a statute of limitations might have run for criminal charges, and as a result, perhaps then it may give someone an outlet of going the civil route?
Well, my view is that the civil statute of limitations is always shorter than the criminal. That's my understanding. In Virginia, anywhere where I practice a lot, the civil statute of limitations is 2 years. It's a short time. Criminal's different. In Virginia, a felony has no statute of limitations. So I don't know what the particular state statute of limitations is for these crimes.
So if, in fact, they file a civil lawsuit and criminal charges have not come forth against a defendant like a Kevin Spacey in this case, is it accurate to say that perhaps law enforcement is continuing to investigate? I mean, it's hard to imagine as a trial watcher, well, if you've got this civil suit filed by these two individuals saying that they were assaulted at 14, where are those criminal charges? Because we should see those too. Is it they maybe haven't caught up yet to where they want to actually proceed? And we'll give you a real short answer here.
I can't tell you the facts of my case, but I had a civil lawsuit filed against my client before criminal charges in another matter. And oftentimes the police will follow that civil lawsuit, and sometimes a civil suit helps the criminal, and vice versa.
Yeah, absolutely. We are going to continue to watch that. Gene, any last thoughts about the Kevin Spacey lawsuit and allegations?
I'm still going to watch House of Cards, but I'm very depressed.
Yeah. It's none of it's good, right? Allegations and et cetera. It's just not a good scenario. Here on Law and Crime Report, we cover the top cases, the breaking news. We've loved having you on with us today. Gene Rossie, I can't thank you enough. I always love your insight, your thoughtfulness, and let's just ask about House of Cards really quickly. Politically, you ran for office. Is any of it accurate from your perspective?
I think about 70% is accurate. Yes.
I finally get to
killing of-
ask an insider.
Yeah. The
So-
killing of Zoe, that's a little extreme.
But other than that, well, it gives us good insight into the political system sometimes. We are going to be ending our show today. Thank you so much for joining us. As always, it's my honor. We'll see you again here on Law and Crime Report. Next time, stay tuned.